Karin Gross is a supervisory attorney in the IRS's Office of Chief Counsel in DC, where she is the National Office Specialist in the charitable contribution deduction. Over the past several years, Karin's work has focused on the charitable deduction for conservation easement donations. She was a member of the IRS's issue management team for easements, and she provides advice to IRS examiners and IRS valuation experts. And her duties in the IRS National Office include recommending conservation easement issues for litigation and assisting field attorneys in crafting positions for that litigation.
Thank you, Nancy, for inviting me, and also for your very good general principles about what 170H actually says and what the issues are. And thank you, Ted, for giving your background at the Treasury Department. It's interesting to hear your perspective, especially since you haven't been involved over the years. And sometimes those of us who work on this all day, every day, we kind of lose the perspective. So that was very helpful. As Ted was talking about, the costs of the deduction are far more than the actual tax expenditure, the cost of lost revenues to the Treasury, because the IRS is spending so many resources in trying to enforce this provision as best it can. And Nancy told you around 2003, 2004, all of a sudden, all this attention was suddenly focused on conservation easements. And at the IRS, we started to look at, is my speaker working okay? Can people hear me? Okay, good. So the IRS suddenly started to look carefully at what was going on. And it was shocking, because what we were seeing was that these easements that people were claiming deductions for, they just weren't complying with the rules. And frankly, we really hadn't focused so much on the issue before, and easements just got looked at by revenue agents, examiners in the regular audit cycles, and the agents weren't trained to look at all the different things they needed to look at, which they need to look at the forms, they need to look at the deeds, they need to ask a lot of questions. It's very, very, very labor intensive to figure out whether a deduction is proper. And to really know whether a deduction is proper, we need to have an appraiser take a look at either the taxpayer's appraisal or do an entirely new appraisal, which is very, very costly and very time consuming. So administratively, it's really, it takes up a lot of our resources. And we started setting up cases for litigation, and lo and behold, the numbers are really staggering. Right now, we have 200 cases that are currently in litigation. And probably for all the other charitable contributions issues that there are, there's probably just a handful. We only see from time to time cases reported out on all the other things, cars, art, intellectual property, all the things, real property contributions that are not easements, all those other things that people give, stocks. Not very many cases get reported out of tax court, but here we have, dozens and dozens, and 200 in tax court right now, and we've had opinions from the courts of appeals and district court as well. So it's really pretty amazing, what's happened. And in my approximately 25 years at the IRS, working on charitable contributions issues, I focused some years on some things. Like there were a couple years car donations was a big deal, and I spent all my time on car donations, or art donations to museums, or intellectual property. So when I started working on conservation easements in 2004, I thought, well, this will take me to 2006. And here we are, it's 2013, and just about all day, every day, I'm working on conservation easements, trying to advise people in the field, our agents, answer questions, come up with litigating strategies, review briefs, analyze cases we've won and cases we've lost, trying to figure out, where we go from here. And we keep moving along. As we develop the law, as we win cases in a certain area, we move to the next thing. And the next thing right now is partnerships. This is going to be the year of partnerships. We are really going to look at conservation easement partnerships to see where the abuse is and what we can do. And we do believe that there is some abuse in the partnership area with conservation easements. So now going back to 2003, what did the IRS do? And I hadn't really taken stock of it until Nancy asked me to address the issue. So thank you, Nancy, for asking me to, because I'm kind of proud of what we've done. Not to say that there's not so much more to do, but we've done an enormous amount of things. And the first thing we did in 2004, we knew we had to do something and get some word out quickly, is we issued a notice, which is IRS Notice 2004-41. And at the IRS, we called it the yellow light notice because it was a warning notice. And Nancy made reference to it. What it said, and at the time I thought it was kind of a silly thing to do, frankly, but in retrospect I think it was good. We said, here's what the law says. Here are the bad things that we think people might be doing. And if we catch you, we are going to impose penalties, we are going to disallow deductions, we are going to enforce the law to the nth degree. And in fact, that's pretty much what we did. We really made good. It took a long time. It's now 2013. But it wasn't just a statement. It was true, you know, and the regulated community took notice. And I think they tried to do the right thing by and large. A lot of the things that we saw as problems, they weren't intentional or things done by taxpayers or land trusts with bad faith. It was just that people were kind of a little sloppy about how they were doing these things. And so they really did straighten up and take the regulated community and taxpayers cleaned up their act pretty much, but not completely. So that notice, 2004-41, that was good. That was a good thing in retrospect, and it really kind of got the word out initially. After we did that, we issued a lot of different forms of guidance from the Chief Counsel's office, which is where I work. One of the things that had been happening was that people were automatically and mechanically taking a deduction just by multiplying the before value of the property, that is the value of the property without the easement. They were just taking like 12% or 11% off of that and just saying that was their deduction amount without actually looking at what the easement was worth or how it reduced the value of the underlying property. So we made it clear in a Chief Counsel advice that's available to the public that that's not acceptable. And so that was the first thing that we did. Then we issued a number of general information letters. And for anybody who wants something in writing from the IRS that's kind of on the easy side to get and quick and free, is just to ask us to issue an information letter that makes a statement of something that we believe to be established law. So, for example, a land trust asked us to issue an information letter saying that you didn't need an endangered species for habitat, for the habitat purpose. People were saying that some of our agents were disallowing deductions based on habitat because the species wasn't endangered, and that was wrong. I don't even know for sure that that was true, but if it was true, it was wrong. And so when someone asked me if we could do a letter saying you didn't need an endangered species for a natural habitat purpose, that was easy because that was right. So we issued that letter, and the Land Trust Alliance posted it on its website, and I never heard afterwards that there was a problem about that. We were asked in a general information letter to say that you couldn't swap out your easement, and that's right, you can't. That's inconsistent with perpetuity. But some people in the land trust community thought that if you didn't like how the easement was playing out over time, that you could just have it extinguished as long as you substituted an easement on other property. And that's not okay. We said that in a general information letter. We thought that the law was clear on that. And in fact, in a recent tax court opinion, Belk, the tax court, said the same thing that we said, that you can't swap out an easement. But we said it first in the general information letter. We also had the question of whether taxpayers had to follow federal law or state law when there was an inconsistency about amendments or extinguishment. And we thought that that law was pretty clear as well, that there are easements for lots of purposes. I mean, people buy easements. Just because you have an easement doesn't mean there's a 170H deduction. But if you want, as taxpayers, if you want a 170H deduction, and land trusts, if you want to be part of that, you have to follow the federal rules. So the state rules don't really matter in that regard. If the state rules have really liberal rules about swaps and extinguishment and so on, that's fine, they can have that, but they still, for 170H purposes, if you want a deduction, you have to follow the federal law. Another thing that we did in 2004, which turned out to be really a good idea, was we established within the IRS something that we called an issue management team. And that's just an internal thing with the IRS, but it was a pretty big deal back then. Because what happens with these conservation easements is they impact lots of different parts of the IRS. The IRS is an enormous bureaucracy, and you have Chief Counsel, which is where I work. You have the national office where I work. You have the field attorneys all over the country, and we have easements in, I think, something I read recently said 49 different states. We have the examination people, the revenue agents. We have the tech advisors who are specialists in the easements or in whatever they specialize in. We have tax-exempt and government entities. That's a part of the IRS that deals with the charities. We have LB&I, Large Business and International, which deals with large amounts of deductions, large taxpayers, corporate taxpayers, and they also have a global high wealth division now. We have SBSE, Small Business and Self-Employed, where most of the easement cases actually live. But we have all different people who do different parts of what's going on. And we also have engineering, which covers the appraisers and appraisals. So we really needed to make sure that we were all on the same page and that we were all focusing on the regulations, congressional intent, the case law, everyone stayed up to date. And that was really a big challenge, especially since our revenue agents are not specialists in conservation easements. They take a return, they're auditing. They audit all kinds of issues from A to Z, things that I have no idea about, but just like I don't know about all the different issues they audit, they might not know all that much about conservation easements. And so they really needed to be educated as to what to look at. And some of it's really technical because our agents have to review the deeds, which is, they're written in legalese, and they may need some help on parsing through all of that. They need to read through appraisals, which are also very specialized by qualified appraisers, and they need to know what's good appraisal methodology, what isn't. So we have our own appraisers who help them with that. But it's very, very challenging. There's a lot to know in auditing a conservation easement. So the issue management team went pretty far in making sure that one part of the IRS was talking to another and that people stayed educated and current on what was going on. Another thing we did was our technical advisor wrote up an audit technique guide. And some of you might be familiar with it. It's kind of a manual on how to audit conservation easement cases. And it's available to the public. And what happened, which was really surprising to me, is the public got a hold of it, which is easy, it's on the internet. And the public started using it as a guide themselves, which is kind of an unintended use of that audit techniques guide, but it's a really good thing because the public can actually look and see what our own agents look at when they want to know how to audit a conservation easement donation. So that was a really good thing, especially since it really is a pretty good work product, I think. It's not up to date any longer, but it's still mostly right still. And we're hoping to update it to take into account the newest legislative changes and case law. And it's over 100 pages. And it's indexed, it's very accessible, easy to read, and so anyone, any member of the public, any person who wants to give an easement, you can see exactly what the examination team, what the revenue agent will be looking at, and where the pitfalls are. And there's special hints, audit hints, on what to look for the agents, and you can know that. You can look at those and see those. So I think that's really good. I'm really happy with how that all turned out. And people have contacted me and said, you know, your audit technique guide isn't really right on such and such a point or isn't really up to date on such and such a point. And we welcome those comments because it's not perfect. I think it's pretty good, but it's not perfect. So keep the comments coming. We want to make it better. Everything we do, we want to make better. So as much as we've done, there's more to do. We also have changed our forms. to help with compliance. So we changed our Form 8283, our Form 8283 instructions. 8283 is the form that you have to file as a taxpayer when you're claiming your deduction. The Form 1023 is for a charity application for recognition of charitable status. We also have a lot of questions now on the Form 990, which is the informational return that charities have to file about amendments and numbers of easements, acres, and so on, which helps us with compliance and enforcement. We do a lot of outreach. We speak at a lot of events. We do continuing training for appraisers with the Appraisal Institute, with land trusts. We try to get the word out, and I think we've done a decent job of that. We've vastly increased the number of audits and litigation, and it takes a lot of our resources, frankly, and we'd rather not do that. But so far, we believe that it's warranted, and we've gotten some court opinions that have been extremely helpful to us, and in getting the word out. We've also imposed penalties on appraisers that have not properly appraised property and have perhaps conspired to have taxpayers overvalue their easements. We've worked with the Department of Justice, and just 2 days ago, as Nancy was saying, an order was issued in connection with an appraiser who was overvaluing property, or allegedly overvaluing property. And one of the things, besides agreeing to be enjoined from appraising for tax purposes, one of the things that he had to agree to do is to turn over the names of all the taxpayers that he has appraised property for since 2009. So I think that when the word gets out about that, people will choose their appraisers more carefully. In sum, I really want to thank all the people who've sent us suggestions, comments, who've told us about people who they believe to be abusing the law, and also all the land trust suggestions and the law review articles that have come out of the legal community, because we really do read them all, and what we're trying to do is we're trying to efficiently and fairly enforce the law so that conservation can continue for generations. Thank you.